As a trial lawyer, I ultimately don't see this as a big deal. In the Blake Lively versus Justin Baldoni case, the judge enlarged a gag order or basically deemed certain discovery items confidential or for attorneys' eyes only. And what I mean by that is, a trial lawyer, we do it all the time, whether it's in state court or federal court, we get presented with confidentiality agreements by the defense. And that means a request asking us, hey, that we will gladly turn over the relevant discovery, but we don't want you to publish that in any way to the media. And that can be for an assortment of different reasons. Oftentimes it's because it deals with trade secrets. So it might be inter-office memorandum. It may be corporate process and procedures where they don't necessarily want it leaked. It could be very difficult things when it comes to communications regarding and/or pornography, tapes, videos. It can be substance abuse records, things that you necessarily could cause harm or prejudice to somebody. Here, that's basically all the judge did. The judge said, hey, I'm not deeming all of the discovery confidential. Specifically, what the judge in this case, Judge Lewis Lehman, said is that all parties in the case can now designate certain materials, i.e. discovery that they're going to produce, as confidential or attorney's eyes only if the information is highly likely, that's the key, high likelihood to cause a significant competitive, business, commercial, financial, or privacy injury should it become public. So what he's saying to the attorneys is review your discovery. If you believe, and again, this happens all the time in federal court, if you believe something rises to the level of this type of confidentiality, you have to designate it. You designate to the other side, we're going to turn it over to you, but it has to be held confidential, and here is why. Now, it doesn't mean the other party has to accept the confidentiality nature. It means they can challenge it and say, hold on, I think this should go above and beyond. I think this wouldn't be subject to this order. Now, that would be just some tit-for-tat lawyering, but the big thing that I think everybody's missing here is this is the discovery phase. The case shouldn't be being tried in the public anyway. There's been so much going back and forth, team this, team that. But the big takeaway is this is discovery. This is evidence to build the trial, and I want everybody to kind of focus on the fact that all of this confidentiality goes away if this thing gets into trial. And why? Because trial's a public record. Think O.J. Simpson, think Johnny Depp, live TV being covered, evidence going in, unbelievable stuff. This is part of the discovery phase, and it does not necessarily mean that it's going to be confidential at trial.